I'll be speaking with you today concerning the structure of H.R. 413 and how it's intended to operate under a variety of circumstances. My prepared statement also addresses the constitutionality of the bill. For the past 20 years, it's been my privilege to represent public safety employees as well as other public and private sector employees and their labor organizations throughout the United States. This has included representation in states where public safety employees have strong bargaining rights and states where they have none. It includes jurisdictions where there is great communication and cooperation between the labor organization and the employer, and again, jurisdictions where there is practically none. That wealth of experience has helped me to assist in the drafting of H.R. 413, and I believe that it takes a very balanced approach to meeting its goals and that it gives full respect to existing state and local laws as well as to constitutional considerations. I believe it is that balance and restraint that allowed this bill to garner such a large number of co-sponsors from both sides of the aisle. Indeed, in the 110th Congress, H.R. 980 passed the House by a vote of 314 to 97 with the support of a majority of the Democrats and a majority of the Republicans. Those distinguished members clearly recognized that the Public Employer-Employee Cooperation Act is not simply a nice thing to do, but the right thing to do and the smart thing to do. Now, as others have stated, there are certain minimum bargaining rights that are protected by H.R. 413. Those essential rights are: 1, the right to form and join a labor organization; 2, a requirement that the public employer recognize and bargain with an association that's been freely chosen by a majority of the employees, and to commit such agreements to writing, and also to have available some type of impasse resolution mechanism. The FLRA will be tasked with reviewing existing state laws to determine whether they substantially provide for the rights and responsibilities I've just mentioned. In doing so, the FLRA is to consider and give weight to the opinions of both the public employers and the labor organizations representing the employees. At this point, one of two things may happen. First, if the FLRA determines that a state or local government already substantially provides the rights set forth in the Act, then the role of the FLRA and the federal government comes to an end, and the state and local jurisdictions proceed as they always have. Second, if a state does not substantially provide for the rights and responsibilities set forth in the Act, the FLRA would so notify the state of this deficiency, and then the state would choose one of two paths to take. The first path is that a non-compliant state may choose to pass its own appropriate legislation meeting the Act's minimum standards, utilizing the methods and procedures that the state determines is the most appropriate way to do that in their individual states. The other path that's available is that a non-compliant state could choose simply to do nothing. In that case, the burden of enforcing and administrating the law would fall solely on the federal government acting through the FLRA. We would anticipate that most states would enact legislation that is compliant, given that the vast majority of public safety officers in the nation are already covered by collective bargaining rights. It's important to understand, however, that nothing in H.R. 413 requires non-compliant states to pass new legislation or to undertake the enforcement or administration of the Act. I'd also like to mention briefly some provisions in the Act designed to respect state rights and address some other concerns that have been raised. Under H.R. 413, it explicitly prohibits public safety employees from engaging in strikes and prohibits their labor organizations from calling for a strike by public safety employees. Presently, no such prohibition exists under federal law. H.R. 413 protects and preserves any duly established bargaining agreement or memorandum of understanding in effect at the time of enactment. It does not prohibit any state law from requiring a collective bargaining agreement or memorandum of understanding to be presented to the jurisdiction's legislative body for approval. In states where the FLRA administers the Act, parties would be prohibited from negotiating provisions that would prohibit employees from engaging in part-time employment or volunteer activities. The Act also allows compliant states with the option to exempt small political subdivisions with a population of less than 5,000 or that employ fewer than 25 full-time employees from compliance with the Act. I appreciate the opportunity to appear here before the subcommittee in support of H.R. 413 and would be happy to answer any questions that you may have.